Discovery should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen, not play word games with me. You're playing with the wrong judge.
I'm not trying.
I'm giving you your warning.
I would like to first have a jurisdiction hearing.
So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong.
This courtroom hearing quickly turns intense when a self-proclaimed sovereign citizen attempts to test the judge's patience. And trust me, it doesn't go in his favor. For those who don't know, sovereign citizens believe they can reject government laws and operate outside the legal system, acting as if the rules simply don't apply to them. What unfolds in this exchange is chaotic, dramatic, and honestly hard to believe. You might want to grab some popcorn, because this one is a roller coaster. Share your thoughts on the hearing in the comments below, and if you enjoy gripping courtroom moments like this, make sure to like and subscribe. Let's get into it.
Hello, Tariq Samar, Tariq Ade here.
Already, Judge Torsho Feaster, Assistant Public Defender, on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office to represent me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
Is this going to be a Bellinger's thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had another counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here, so I don't know what's going on, Your Honor.
No,
Mr. Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this case.
So you're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no way I can.
In a vehicle with a hat on, no mask. Oh.
I am inside my vehicle right now.
What'd you say?
I said yes, because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital starting the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're going to do. Then I'm going to say, okay, you've got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're going to represent yourself.
I can't make that. Is there a later date?
Oh, yeah, you can. 3 o'clock.
3:30, I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then
okay. And at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See
didn't
you at
have.
3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line.
Spoiler alert. He actually showed up at 3 o'clock, even though he insisted he'd be there at 3:30. That alone says a lot. It's pretty clear he understands the judge has authority over him, despite whatever claims he's been making. And now the judge is about to confront him for misleading the court, which is a serious mistake. In the legal world, lying to a judge can fall under contempt of court, and that can bring real consequences. Instead of helping his case, he's wasting everyone's time and setting himself up for a harsh reality check. Court isn't a playground, and this isn't a game. What do you think about his approach? Personally, trying to mislead the court doesn't seem like the smartest move, but that's just my take.
Sir, you indicated that you wish to represent yourself on this matter?
Yes.
All right. You understand at your arraignment you were given the charges that were have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding,
Fleeing and eluding third degree.
third degree, correct. And if anything else was tallied onto that, then I was not told.
Okay. I have one charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
First, I wanted like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of a personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party, Wall Street Towing, and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser, with the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
I'm genuinely trying to understand this guy's logic. First, he misleads the judge about a situation. Then he walks into court without a mask and starts insisting the court has no jurisdiction. On top of that, he argues the case should be dismissed because there's no injured party. It's honestly baffling. For starters, if you're standing inside a courtroom before a judge, that's usually a pretty clear sign the court does, in fact, have jurisdiction. And the whole no injured party argument, that doesn't automatically invalidate a case. There are plenty of charges, especially something like fleeing and eluding, that don't require a specific injured person to move forward. He's presenting these arguments with a lot of confidence, but confidence alone doesn't make them legally sound. So far, this strategy doesn't seem to be helping his case at all. Let's get back into it.
Finish.
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust. And I'll be able to supply you all with the adequate assurance, certificate of security to settle and offset the charges.
Okay. Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing,
This is a probable cause hearing.
so I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was
You weren't able to do what?
provide my exhibits
To whom?
to the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So They will be here, if not by the end of the day in the drop-off box, and you'll have more tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not this time.
All right. So how would you like to proceed next on this?
I'm entering a plea of demurrer.
Okay, you've already done that.
Judge Simpson is done with sovereign citizens. Is it just me, or is anyone else starting to feel a little bad for this guy? He's getting absolutely dismantled in court right now. You can tell Judge Simpson has reached his limit with these sovereign citizen-style arguments. The defendant seems to think he's at some informal preliminary discussion, but in reality, he's completely outmatched. He's confidently making points that don't even apply to this type of hearing, insisting on evidence requirements that just aren't relevant at this stage. It's uncomfortable to watch because he clearly doesn't understand the process. Instead of representing himself with arguments that aren't landing, he could have taken advantage of legal aid and gotten proper guidance. That's exactly why those resources exist. But instead, he's choosing to debate the court as if persistence alone will win the day. What do you think about his approach? Let's get back into it.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer.
You stood mute, you stood demure. You don't even know what that means. You're just using words and have no concept as to what they mean.
Demurrer and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not. They are not.
No need to-
They are not.
I'm not here.
They are virtually the same thing. So where do you wish to proceed now?
As I stated, my motion.
Do you wish this set for preliminary examination? Your motions have been
I
denied.
wish for the prosecution to provide the evidence that any of this needs.
You don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about
Do
it.
you wish to have
Discovery
discovery?
should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen,
Discovery.
not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes.
Sir, did you wish to then have another PCC, or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing,
What kind of jurisdiction here?
personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
Do you think he's pretending not to understand, or is he genuinely confused? He's now asking for a jurisdiction hearing, but that's something typically raised right at the very start of a case. A jurisdiction hearing is meant to determine whether the court even has the authority to handle the matter in the first place. If someone truly believes a court lacks authority, that argument is usually made before the case moves forward, not in the middle of proceedings. At this point, the court clearly already has jurisdiction. He's physically present in the courtroom, the case is scheduled, and the process is underway. You can't simply request a hearing and expect everything to disappear. It doesn't work like that. It makes you wonder where he's getting his legal strategy from, because this approach doesn't seem grounded in how court procedure actually works. What do you think about his tactic? Let's get back into it.
This court, as well as the state, lacks personal jurisdiction. I'm simply here under threatened arrest or coercion of you, saying that you would hope put out a bench warrant for my arrest. The subject matter, in regards to the name as well as the vessel that was used, is again under. It was conveyed and is held and protected within the trust. And according to Article 1, Section 10, Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly properly functioning at this time. So with that.
All right, so here's what we'll do, because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong, because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
Awesome. So that would be the next step, and I can get those in today.
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
Yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine, and then I will file the proper documents for the jurisdictional hearing. Gotcha.
So I'll adjourn the probable cause conference in this case, April 25th, 2024 at 3 p.m.
Is it possible to get another week for
person
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple counsels extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable
setting the date
so
of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PCC, to a preliminary examination.
Just for the record, I'll put it on the record that I object, but under threat, direction, or coercion. Again,
your objection is noted.
Right, and under threat and direction, coercion, I'll be here.
Is there anything else?
I said what I need to say.
Anything else from the people?
No, Your Honor. Thank you.
Bond will continue.
Am I waiting for paperwork or I get it from the front?
Pardon?
Am I waiting for paperwork regarding the next?
No, you may leave.
Oh, is it being mailed? Or I'm trying to figure out how to get the paperwork.
You can check out at the front counter.
Okay. Thanks.
I know this guy identifies as a sovereign citizen and clearly isn't approaching this in the most rational way. But do you think Judge Simpson was too harsh with him? The judge was definitely direct and firm, maybe even blunt at times. But personally, I don't think it crossed the line. If anything, it felt like a necessary reality check. The defendant walked in seeming like he could turn the courtroom into some kind of debate stage. But Judge Simpson made it clear that court isn't a game. Maybe this experience will push him to actually prepare properly next time and consider getting legal representation. That's what those resources are there for. The broader issue is that these sovereign citizen-style arguments seem to be gaining traction online. A lot of people get pulled in by conspiracy theories and supposed legal loopholes, believing they can sidestep responsibility just by rejecting the system. Social media has amplified those ideas, and now we're seeing more of these arguments show up in real courtrooms. At the end of the day, court proceedings are serious. When someone comes in unprepared and refuses to acknowledge the court authority, it slows everything down and costs time and public resources. A firm response from the bench may actually discourage more of this behavior in the future. What did you think about this hearing? Was Judge Simpson too tough? Or was he simply enforcing the rules of Courtroom? Share your thoughts in the comments. And if you enjoy content breaking down real courtroom moments like this, don't forget to like and subscribe. Thanks for watching. Take care.